Good evening, everyone, and thank you for joining us for tonight's webinar on retention elections. Thank you to our co-sponsors, the Committee of 70 and Pennsylvanians for Modern Courts, and thank you to the Pennsylvania Cable Network for recording this evening event. PCN will upload the recording to PCN Select and PCNselect.com, and the League will also be posting this recording on our YouTube channel. I am Amy Weidstrom, the Executive Director of the League of Women Voters of Pennsylvania. The League of Women Voters of Pennsylvania is a statewide, nonpartisan, nonprofit member organization that does not support or oppose any political party or candidates. We regularly host educational and candidate forums to provide voters with the opportunity to learn more about the election process and how to be engaged and empowered voters. Our hope is that this event will help voters make more informed decisions in the fall. As a reminder to our viewers, this is a virtual event, which means everyone in attendance is muted. If you would like to ask questions, please use the Q&A function on your screen. Also, please remember that if you'd like to add closed captions, you can select Show Captions on your Zoom dashboard. In the first part of this evening, our presenters, who have firsthand experience, will describe the extensive investigation and evaluation of judicial candidates that are conducted by nonpartisan lawyers organizations. These organizations, or bar associations, both at the county and state level, investigate, interview, and evaluate judicial candidates. Our presenters are bar leaders from a county bar association, the Lancaster Bar Association, and from the statewide Pennsylvania Bar Association. They will also explain how non-lawyer voters can access this information. Both the conclusions and some of the raw data is published by bar associations. Our second panel will focus on a specific type of judicial election, retention elections. Deborah Gross from Pennsylvanians for Modern Courts will give an overview of what retention elections are and what they are not, and will moderate our panel. We are privileged to hear from two judges who ran initially for open seats and then again in retention elections. So, to kick us off, it is my pleasure to introduce Colleen Connelly. Colleen serves on the Board of Directors for the League of Women Voters of Pennsylvania and is a member of the Radnor Township League. She is a lawyer with more than 35 years of experience in civil litigation, including voter protection work, and in clinical law teaching and direction of pro bono legal programs. She is currently a legal consultant on the Women's Law email hotline of the National Network to End Domestic Violence and serves on the Pennsylvania IOLTA board by appointment by the Pennsylvania Supreme Court. The IOLTA board is the largest funder of civil legal aid in Pennsylvania. So now I pass it to Colleen. Hi, Colleen.
Hi. Thank you, Amy. As Amy said, the State League hosts these free educational programs open to the public. You can see our previous programs all on our website. I have to give a shout out. The State League convenes a voter services working group, which is 80 some local league members from around the state who get together and work on all kinds of things. One of those things is planning an idea for educational programs like this one. That is in addition to all the work they do in their local leagues, which is a great deal. So I want to thank them for all of their hard work. I want to particularly thank Carolyn Hernandez, president of the League of Women Voters of Lancaster County, who connected us with our speaker from Lancaster County and does so much. So I just want to give an extremely brief overview, and we have all this on our website, and all of this is on the Pennsylvania Unified Judicial System website, what the 4 levels of the courts are. There are the minor courts where you might go for traffic type cases. Then there are trial courts, and that's where things are litigated. There's maybe a jury trial. And those courts in Pennsylvania are called the courts of common pleas. The next level we have 2 intermediate level appellate courts, They have a slightly different jurisdiction, meaning jobs that they do. And then the ultimate court is the Pennsylvania Supreme Court, and that's the court of last resort on Pennsylvania law. So the county bar associations evaluate candidates for the court of common pleas in their judicial district. And the Pennsylvania Bar Association, which is the state level bar, evaluates all statewide judicial candidates. So that would be Superior and Commonwealth as those two intermediate appellate courts, and the Supreme Court. Some bar associations, and one of our speakers will mention this, also conduct evaluations of some candidates for appellate courts if they live or work in that county. I want to introduce each of the speakers, one after the other, and ask about the work that their bar association does to produce these ratings of judicial candidates. It's nonpartisan. They don't do endorsements. They're going to give you an analysis side by side. The work of the bar associations is just one resource for voters to make informed decisions. We have a great deal of information on the League of Women Voters website, and we have a excellent online voters guide tool called Vote 411. It gets Webby Awards for being a terrific website. And we also hound these poor candidates and ask them to answer our questions, and then we post them again, side by side, right from the horse's mouth, so that voters can decide. So with all of that, I would like now to turn to our two speakers. The first is Jennifer Coatsworth. She's a partner at the law firm of Margolis Edelstein in Philadelphia. Jen has litigated hundreds of motor vehicle, dealer fraud, and lemon law cases. Her firm has 9 offices in Pennsylvania, New Jersey, Delaware. Jen was a member of the Judicial Evaluation Commission of the Pennsylvania Bar Association from 2017 to 2022. And you'll notice even tonight that different bar associations give a slightly different title to their commission or group that does these evaluations. Jen is also a former chancellor, that means the president, the head of the Philadelphia Bar Association. She was served in 2024, so she can share some insights about the Philadelphia Bar Association's Judicial Commission. So with all of that, I'd like to welcome Jennifer Siegel Coatsworth.
Thank you so much, Colleen, and thank you to the League and Pennsylvanians for Modern Courts and Committee of 70 for hosting this event tonight and for allowing me to be a part of it. As Colleen mentioned, I have served in dual roles in both the Pennsylvania Bar Association's Judicial Evaluation Commission, as well as the Philadelphia Bar Association's Judicial Commission. So I'll speak first as to the statewide organization. I served on that commission for about 5.5 years, as Colleen mentioned. And it is the statewide bar's mission to evaluate candidates for statewide judicial positions. So as Colleen mentioned, the Pennsylvania Supreme Court, as well as the Superior Court and the Commonwealth Court. The Pennsylvania Bar Association does not evaluate any candidates for any of the county bar trial level courts. And it's a very formal and very detailed process. Both the Pennsylvania Bar Association and the Philadelphia Bar Association conduct very, very thorough investigations of all of the candidates. So it starts out with, and I'll sort of speak about them in a parallel way because a lot of the process is similar, but then I'll also tell you about how they diverge a little bit. So in both processes, it starts with the candidate sort of declaring themselves for candidacy and seeking information from the Bar Association for the investigative process. So they are provided a packet. They have to complete a questionnaire of a very detailed questions and answers, which gives basic background about that person's practice up until that point. It gives some personal information about where they live. And that information is then publicly available to anyone to find on the internet. So those questionnaires with those questions and answers, which are sometimes very detailed, can be found for judicial candidates on the internet. And then once they complete that, they also fill out some authorizations, and they fill out some pledges regarding sort of oaths about ethical considerations and things that they pledge they will or will not do from an ethical perspective, which the Bar Associations find to be very important with regard to advertising and things of that nature. Once the questionnaires are complete and the paperwork is filled out, then the Judicial Evaluation Commission assigns an investigative team that conducts background information. They do their own internet searches. They look up the person's their professional history. They look to see if there have been any lawsuits filed against them, if any there criminal charges, ethical charges against them. They look at their social media presence. They also conduct interviews. Each candidate is requested to give, I think it's 20 different references. And so the investigative teams follow up, they call or email all of the references that the candidates give, but they also do their own investigation as far as they may find somebody who the candidate did not name as a reference, and they may call that person sort of out of hand and request information about the candidates to see what their experience, that person's experience may have been with the candidate. This can be opposing counsels, this can be judges, this can be clients, other members of the profession who may have interacted with the person in a professional capacity, whether it be with the Bar Association or some other organization, social organizations that the candidate may be a part of. So it's a very intensive and very thorough process. Once the investigative team conducts their investigation, the investigative team conducts an interview with the candidate to make sure that what the candidate says matches up with the investigative team's findings. They also ask the candidate about why they want to hold the position of judge, what they think they can bring to it. They ask questions regarding inclusivity and belonging. And so it's a detailed interview. The interviews usually last about an hour or so with the investigative teams. The investigative team then writes up a report based upon their full investigation, as well as the interview that they conduct with the candidate. Then it goes to the commission itself. And the commission for the Pennsylvania Bar, the commission is made up of both lawyers and lay people from across the state. So there are a certain number of lawyers, and there's at least 3 or 4 lay people, maybe 6 lay people who also serve on the commission. So non-lawyers, but they may have professional interactions with lawyers, which make them a little bit more qualified to see what you're looking for. Then the commission looks through all the information, the candidate questionnaires. The candidates provide writing samples as well for work that they've done. And then the Judicial Commission reviews all of that information, including the investigative team's report. And then the commission conducts their own interview of the candidates. Pre-COVID, those interviews for the Pennsylvania Bar took place in Harrisburg at the Bar Association's offices. Since COVID, those interviews have now been conducted mostly virtually on Zoom. And those interviews also can last up to an hour or more, and the commission takes its time to really probe into everything that the candidate has said, both in their written submissions as well as in their prior professional lives. And then there's an extensive conversation, which is all confidential. The commission members are sworn not to disclose to either the candidates or other members of the public as to what is discussed within those sort of debate sessions over what to do with the candidate and how to rate them. And then the commission comes out with a rating, which is voted on by the commission. So the Pennsylvania bar has 3 ratings. You can either be not recommended, recommended, or highly recommended. And I believe in order to, if my memory serves, to get a highly recommended, you need 80% of the commission members to vote highly recommended. So it's not just, it's a very high bar. When you see a highly recommended candidate, that person has really reached the pinnacle of their career and is really a very prestigious designation to have that highly recommended designation. Recommended, you need a majority of the commission to vote in favor of recommending the candidate. So it's also, since they've been through such an extensive process, that is also a very meaningful designation to get that recommended rating. And it's important to note, as Colleen alluded to, a recommendation is not an endorsement. There can be multiple candidates with any one elections within any one election cycle that receive that highly recommended and certainly receive recommended ratings. So that is not an endorsement, it's just a rating. But they are important. And as you may have seen in the commercials that are on TV right now for the retention elections, the candidates, once that rating comes out, the candidates are free to say they are recommended or highly recommended by the Bar Association. There's sort of a different process with the not recommended, where if a candidate is told they are not recommended, then there is a process by which they can withdraw if they desire to do so, to avoid a publication of the not recommended rating. And then they can reapply in the next cycle if they decide they want to run for another cycle, in another cycle. And I see Colleen coming on. I just want to give a few seconds about the difference between the Philly bars ratings and the Pennsylvania bars. So the difference, the main difference, the process is very similar for the Philly bar as to the Pennsylvania bar. But the difference is that sort of, number one, Philly bar is rating only the candidates for the trial level judiciary in Philadelphia, plus any statewide candidates who live or practice in Philadelphia. So not all of the candidates are rated, statewide candidates are rated in Philadelphia. And the other big difference between the two bar associations ratings is the publicity and the method of publicity. So the Pennsylvania Bar puts it on the Pennsylvania Bar's website and does some work in trying to disseminate the ratings throughout the legal community for sure, as well as getting the ratings out to local media as much as they can. The Philly Bar has undertaken a very concerted effort to get the ratings out. And it's a little easier because it's a more concentrated geographic region in Philadelphia. So we've retained consultants, marketing consultants, that have helped us to disseminate the ratings. And we've used direct mailers to locations where there are high concentrations of folks who vote in judicial elections. We have also employed our members on a volunteer basis to go to polling places and to specifically hand out our ratings to voters on election day. So that's been a very impactful method of disseminating our ratings, and we've found a lot of success in getting only candidates who are rated recommended or highly recommended on our judiciary. In the last, I believe it's 4 election cycles for Philadelphia, only candidates that have received recommended or highly recommended ratings from the Bar Association have won seats, despite their placement on the ballot. So that has been a really big win for the Bar Association. We're very proud of the efforts that we've made to help educate the voters on the qualifications of the judicial candidates.
Thank you so much, Jennifer. I have a couple of questions that we're getting in, but I'm going to turn it over to Jeffrey. And because I know Jennifer has to leave, she's double booked this evening. Pardon me, I'm sorry, everyone, I have a little cold. But we will get to those questions. So now if I could turn to Jeffrey Willett. He's the managing partner at, oh, I didn't ask you how to pronounce Appel Yost?
Apple Yost, yes.
Apple Yost. I should have asked that. The firm has multiple offices in Lancaster County. Jeff practices principally in the areas of estate planning and administration, business law, commercial litigation. He's practiced for nearly 30 years in Lancaster, Harrisburg, and Philadelphia. He's a past president of the Lancaster Bar Association and currently serves chair of the LBA's Judiciary Committee, and they are tasked with evaluating candidates for the local bench. So with that, I'll send it to Jeffrey.
First of all, I would like to echo Jen's sentiments and thank everyone for their participation. I really appreciate having the opportunity to be here. Jen did a great job of giving you the basics of the evaluation process. And so I'll try to streamline what we do here in Lancaster and then allow a lot of our listeners to ask questions and try to move forward on the Q&A. So to give a little bit of background in Lancaster, we have a committee, a judiciary committee of 17 individuals. It's provided for in the bylaws, and we have about 800 members. So really what that does is it gives us a nice cross section of individuals in different practice areas, in firms of differing sizes, from solo practitioners to large practitioners, because we're trying to get as diverse a group involved to evaluate those candidates as possible. So that's really our stated goal moving forward. As Jen mentioned, initially the candidates will express an interest in moving forward. What the Bar Association in Lancaster will then do is send out information. It's an email request for all our members to evaluate the candidates. And we ask them to evaluate them in one of 3 ways: either recommended, not recommended, or insufficient knowledge to evaluate the candidate. And we tally all of that information. In addition, we ask the candidates to complete a questionnaire, much like you see on the statewide bar, and provide it to the Bar Association for review, particularly of the committee members, those 17 committee members that I mentioned to you. So as we're compiling that information, we also have an investigative division. Now, because we're not nearly as large as the Pennsylvania Bar, nor do we have the same number of candidates, we only had 4 investigators, and they're typically highly respected members of the Bar Association who are retired. They may be judges, including administrative law judges. They may be longtime trial practitioners. And we would typically, for every candidate, assign a couple of investigators. So we assess the overall response to these candidates from our membership. We have the investigators try to interact with all the candidates and get information from them. We don't suggest a specific number of recommendations, but we're glad to have referrals of individuals with whom they would like the investigators to speak, to learn more about their qualifications, their temperament, and other things that are material to their candidacy. In addition to that, they also investigate outside the scope of the candidate's recommendations and talk to others who may have been adversaries in the courtroom or members of the existing bench, partners, staff members, even clients. So we get a well-rounded view of the candidate. because being an effective judge is not merely your courtroom demeanor. It also has to do with how you perceive yourself, how you relate to individuals in the community. Certainly, legal acumen is extremely important, and I'm not trying to minimize that, but we also like to get a well-rounded view of the candidate as a whole. So what will then typically happen is we will ask the candidates who move forward through the process to get together and talk to our investigators, and then go through a formal interview process with the 17 committee members. The way that we conduct it is the investigators will gather background and report back to the committee their findings generally and see if they comport with what the candidate says are strengths, areas for improvement in the questionnaire. And then we will have a back and forth with the candidate to move forward and delve and probe a little bit more into areas of interest. Again, whether they may be areas of strength or areas where improvement may be needed, ideally, if they do become a member of the bench. After we gather that, we get together, have the committee members, and we all vote. And there are 3 separate ratings that they can get, consistent with what you heard earlier from Jen. We have highly recommended members, we have recommended members, and we have not recommended members. In order to achieve that highly recommended threshold, we need 2/3 of the Judiciary Committee members to so rate the candidate. And again, as a general rule, there are 10 separate criteria we evaluate, but it goes generally to legal acumen, judicial temperament, and overall character and professionalism. So we evaluate all of those things, come out with ratings. On the evening after the committee has met and rated the candidates, I will personally reach out and contact the candidates and let them know how the committee evaluated them and what the process was, give them some basic rationale as to why the committee concluded what it concluded, and then give them a window of time, say 2 to 3 business days, to decide whether they'd like to move forward. In the event they advise that they would like to move forward, then we will publish a summary, and that summary will include whether the candidate participated actively in all aspects of the evaluation, part of the aspects, or none of the aspects of the evaluation. We will publish the overall ratings by our entire membership, and then there will be a 2 or 3 paragraph summary of the candidate's, first of all, experience, and then the committee's view of them as a candidate, strengths, areas where perhaps they're not as strong as other candidates. So we'll go through that process and publish that. Those publications will be both on the Lancaster Bar Association website and also typically provided to the local paper, who will then move forward and run those. So there will be some publicity regarding the individual judicial evaluations. And then after that process, much like Philadelphia, we will have some members of the committee not advocate, not endorse, but in fact go to polling stations and provide summaries of the Lancaster Bar Association's conclusions.
Well, Jeff, thank you so much. Really appreciate it. We had one follow-up question. I just wanted to ask both Jen and Jeff. So they're not endorsements. You can and do always give a rating to, say, somebody of one party and somebody else of another party in the same race, right?
Yes.
And all these procedures that you described, how big the commission is, the investigators, all those procedures are on your website, aren't they?
They are.
Yes, they are. They're available publicly.
Yes, okay, and we had a question about how does a non-lawyer learn how to get on that PBA commission, Jennifer? I don't know if that's on your website or if you know. If you don't know,
So typically it's somebody who's on the radar of somebody who's on the commission, and they make a recommendation to the Pennsylvania Bar Association president. The Pennsylvania Bar Association president is the person who appoints everyone to the PBA's commission. And they do make efforts to ensure that there is diversity of geographically as well as by party. They try to keep the party affiliations even on the
Right.
commission, including the lay people and the lawyers who serve on the commission, but it is essentially an appointment of the president. So you sort of have to come on the radar of the president. And I also just wanted to state that Jeffrey did a wonderful job of delineating the qualifications and the nature of the qualifications, which I think are pretty uniform across the Pennsylvania bar and the Philly bar as well, as to what you described as to what the commissions are looking for: temperament and judicial and legal acumen and general judicial temperament and character.
And just one last point, I think it's true that all of the commissions do the recommended, not recommended, highly recommended for first time candidates for an open seat. But for retention candidates for any level seat, it just recommended or not recommended. Is that right?
Yes,
So
that's correct.
if we saw ads saying that somebody got the highest recommended for the retention in the Supreme Court, it would be true if they said, if they were recommended. Is that?
It would be true, probably based upon a prior rating from when they ran for the first time.
Got it. Got it. Well, thank you both so much. And Jennifer, thank you for splitting your evening. And we have lots of resources in the chat and are available on our website. I know people were asking about the questionnaire. I know the PBA publishes both the questionnaire and the candidates' answers to the questionnaire. And you also publish the pledge that
Yes,
candidates make. So it's all
exactly.
right there. So thank you both, and we're going to turn it over to the second part of our program. And
Thank you, Colleen.
we really appreciate it. Okay, so next we're going to turn to Debbie Gross, who's president and CEO of Pennsylvanians for Modern Courts. It was formed in 1988. It advocates for a number of judicial reforms, merit selection of appellate judges being the most noteworthy. PMC also serves as a community educator and proponent for access to justice. Debbie has over 35 years of private legal practice in federal and state courts all over the country, and concentrating on complex litigation. She was chancellor of the Philadelphia Bar Association in 2017, and she focused her efforts on the legal nonprofit community in Philadelphia. And she also spoke out, seems quaint now, on the importance of judicial independence as the cornerstone of our democracy. So we thank her for her service, and she has put together a fabulous panel here. And I'll turn it over to you, Debbie. Thank you.
Thank you very much, Colleen, and thank you to the League for pulling this together. And with PMC and Committee of 70, I would be remiss to say, if I didn't say that this year is a very important election year. Every year is a very important election year, right? But odd number years, we have a track record in Pennsylvania of having 20% of our registered voters turn out to vote. We are hoping that these programs help inform you, educate you, so we increase the number of voters who come out to vote. Voting is just an important part of our democracy. So that's my little advertisement. Um, so I want to thank very much the two judges I have on this panel. I have Judge Bonnie Ledbetter, who is a senior judge for the Commonwealth Court. And I'm going to let Judge Ledbetter explain what the Commonwealth Court is, because it's a really unique court to Pennsylvania. But her path to this court is also interesting in that she was first nominated, then confirmed, then she ran for election, then she ran for retention election. So she has a wide range of experience, I'll say, in her candidacy for this position. I also want to thank Judge Lisette Sheridan Harris for joining us. Judge Sheridan Harris also was actually retired now. But that doesn't mean she's given up her judge hat. I want you to know, because you're teaching, right? Don't you still teach for new judge school? Right. So she's still helping teach other judges about how to be judges, which is really important in this day and age. But Judge Sheridan Harris was elected to the Court of Common Pleas in Philadelphia. She ran again for retention election. She was appointed by the Pennsylvania Supreme Court as the administrative judge over the over the First Judicial District's Trial Division. It's quite a mouthful, but it's overseeing civil, criminal, family, orphans court. It's a lot of, well, actually civil and criminal, I should say. And it's a lot of judges that she has to oversee. She was in that position during COVID, not an easy task. So, we have a really special panel here, and I want to thank you both for joining me. So I want to first talk about the difference, right, between judicial elections, which we do have, there's been a lot of talk about, and retention elections. So, Judge Sheridan Harris, what is a retention election?
So one of the biggest differences, and anybody that's attended the other panels, you've probably heard that when you run for election, it's nonpartisan to the extent that you can be on both ballots. You can be on the Republican ballot. You can be on the Democratic ballot. When you run, you can run on both.
In the Court of
Common Pleas. Yes, in the Court of Common Pleas. Yes. And you know what? And I will limit this to Philadelphia. In the Philadelphia Court of Common Pleas, you can run on both Democratic and Republican ticket. When you run for retention, the idea is that once you take a seat on the bench and take that oath, it is a nonpartisan position. And when it is time for retention, it is nonpartisan. It's a yes or no. You don't have to declare Democratic, Republican again in Philadelphia. And so for that reason, by the time you run for retention, hopefully enough voters are informed and spoken to other people and understand the different judges that are running for retention. They've had a chance to hear about, if not experience firsthand, a judge's temperament, a judge's integrity, and most important, understanding the need for the independence of the judiciary and stability. You have judges that have had 10 years of experience, no matter what that was. We could go into more what specifically in particular we've done, but you've had 10 years of hopefully experience and background for people to say yes or no. And hopefully for most judges at that point, they've done a good job and will be retained to continue doing the good work for the citizens of Pennsylvania.
Thank you. So that's important, right? You're a judge for 10 years before you run for retention election. And that retention election is literally a question, and everybody know it's on the back of the ballot if you have a paper ballot. So make sure you turn the ballot over. And the question is going to say, should this judge be retained for another 10 years? Judge Ledbetter, what was, you ran for both, you were appointed, you had to be confirmed, you ran for election, and then you had to run for retention election. And can you tell us a little bit about the court that you did this, the Commonwealth Court, and what that court does? And I know that there's a difference in the appellate process, and that you can't run on both ballots. So do you want to share a little bit about your experience? Wait, you're muted. No, still muted. Hold on. Michael?
There.
There.
Commonwealth Court, sorry, is I took too much to heart. The turn your camera and your microphone off. Okay, Commonwealth Court is one of the most unusual courts in the country in that we are primarily an appellate court, which means we hear appeals from the courts of common pleas and also from state administrative agencies. And we hear that like any other appellate court. We sit in 3-judge panels, and also the court in Bank sits as 7. And we spend most of our time reading briefs and writing opinions. We spend only a very small fraction of our time in the courtroom, and that's hearing oral arguments. But the unique thing about our court is that in addition to our appellate jurisdiction, we also have an original jurisdiction, which means we act as a trial court. And in that capacity, we hear any suits against the Commonwealth government, against a state agency, or a state, with some technical exceptions that I'm not going to get into, or a state officer. So if someone sues the governor or the head of DHS or some other agency and says, you're doing something that's unconstitutional or illegal and we want you to stop, then that would come to us for a trial. And often, often the facts aren't disputed and it would just become a legal issue for us to decide. But we have jurisdiction over election court, over land use matters, zoning, that kind of thing, labor matters. I'm blanking on all the many different things that we do. Unemployment compensation, workers' compensation, tax cases, all state appeals from the State Board of Finance and Revenue, appeals from the Public Utility Commission. We sit as bankruptcy court in all insurance company insolvencies and all municipal insolvencies. I actually supervised the insolvency of the Reliance Insurance, which was a huge insurance company before it became insolvent and was liquidated. I also supervised the insolvency of the city of Harrisburg, our state capital, and they successfully came out of supervision, and now they're doing pretty well.
So it's interesting because these cases are I'm going to say pretty complicated. So
they are.
So you've served for 10 years and you've gained some expertise, I'm going to say, right?
Okay.
As a judge. And is there a difference between when you first run as a candidate, right? And you're
Sure.
going to say a newbie.
Yeah.
And then you're running for retention election.
Well, there's a big difference. For one thing, it's when you're running against, in these partisan elections, it's generally one Democrat versus one Republican. There are ways that third-party candidates can get on a ballot, but the process is so difficult that I don't think there's ever been a situation in our state anyway where it wasn't a Republican versus a Democrat in this first judicial election. So you have to work with the party. You have to fundraise. Now, judges and judicial candidates are not allowed to personally ask for money, and they're not allowed to personally take the money. But of course, you have to know who's given you the money because you have to file financial disclosure forms with the Department of State. So there's money in it, and you have to go around the state campaigning, and theoretically, that should not have to happen in a retention election where you have no opponent and it's just a yes no vote, and it's intended to be nonpartisan. If I can digress for a minute, I think this is kind of interesting in light of what's happening this year. The both the Commonwealth Court and the concept of retention elections came to Pennsylvania through the Constitutional Convention of 1967-68. And with respect to retention elections, the planners said this about what they envisioned retention elections to be. They said the system combines the direct election by the people, that is, having a first partisan election and a later retention, with a nonpartisan, non-competitive reelection, but it eliminates the rigors of a campaign for the incumbent judge, retains his skill and experience, and permits the electorate to pass on his qualifications and fitness for office as demonstrated by his prior term of office. The election contemplated does not follow the usual type of political campaign, since the judge who seeks to be retained for a regular term runs on his own record. He does not have to spend the time, physical, and mental energy, nor the money required by a typical partisan competitive campaign. His only investment in effort and money to be retained is in the work he has put into his judicial duties to gain a satisfactory record and the cost of a postage stamp used to notify the election officials that he desires to be retained for another 10 years.
That's a wow.
We can see,
That's a
yeah,
wow.
that was what they thought it was going
Wouldn't
to
that be nice?
Yeah, and right. And one of the opponents of this concept of retention election, one of the delegates said that, oh, wait a minute, said that that was just like giving judges life tenure once they were elected, because you can't lick somebody with nobody. So he thought nobody would ever lose a retention election. Well, I'm going to let you ask another question, but we've seen the history of what's happened since that time,
Right.
and it's not quite what they expected.
No, I mean, when each of you ran for retention elections,
Yeah.
you know, did what was that like? I mean, you know, then we'll go to what's going on now. But what was that like when you each ran as a retention
I'm going to
candidate?
defer to Judge Sheridan Harris first, and then I'll tell you about mine.
Okay, so the first thing is when you're approaching your 10 years, you hear from everybody. Again, when I first ran, and again, this is Philadelphia, it might as well be statewide because we have wards throughout the city that you have to go to areas of the city you've never seen before, you've never been in. You have to you're beholden to every ward leader across Philadelphia. And when it's time for retention and it gets close, people tell you, don't worry, sit back, relax, kind of like what you just read, Judge Ledbetter. Just sit back, let your record speak for itself. Nobody relaxes until after the election. So for me, a big part of retention was making sure that I stayed visible in the community, making sure that I did what I needed to do. So when it came time for retention, people, if nothing else, would recognize my name. But I didn't relax, and I don't think most people that run for retention, um, even though statistics are more likely than not up until now that you would be retained, you always assume that you may not. And so there's a level of anxiety, but you go into it just hoping and praying that enough people uh, can speak up for your work. And so it's a very big difference in that initially you are running until polls close. Retention, not quite, it's more an anxiety than a physical going to all the same locations.
Did
Thank
you,
you.
if I
Yeah.
can ask, did you form a committee and get
So,
money?
so what I did, it's interesting you asked. What I did, I had no idea about what running for judge looked like. So I had seen enough
I mean, as a retention
national
candidate.
campaigns that I knew what I needed. And I formed, everybody thought I was insane. I formed this huge, huge committee with everybody from a PR person to a street person to my finance committee to, I had around 20 people and I met on a weekly basis from the time I decided to run until the polls closed. So
And
I did.
was that
No,
for
my question
retention?
was
Was that for
about
No,
retention?
this
retention.
is when
Yeah.
I ran initially.
Okay.
When I
Yeah.
ran for retention, I had nothing but myself.
Right.
How about you?
Yeah. Well, uh, backing up 2 years before my retention year, which was 2007, Russell Nigro became the first appellate judge in Pennsylvania to lose a retention election. And
And
there's,
and so everybody knows he was running for retention as the Supreme Court justice. And go ahead, Your Honor.
correct, correct. Well, and my recollection of that election was that Russell did not really get out and campaign or get out aggressively. Sandra Newman was also a Supreme Court justice running for standing for retention the same year, and she did. She very aggressively campaigned to keep her seat. And in fact, I believe that then Governor Rendell did robocalls for her. Now, that was not non-political, because obviously it was political, but it was nonpartisan in the sense that she was a
Right.
Republican and he
Yep.
was a Democrat. And
Right.
he stood up for the principle that she had been a good justice and did not deserve to be thrown out. Anyway, she won and Russell lost. And 2 years later, because of a midnight pay raise by the General
Right.
Assembly, the voters were unhappy. And so there was a concerted effort to try to get all of the judges non-retained. There was a bus that was painted pink and it had a big snout on it. And the pink pig went all over the state saying, vote no for all the retention judges. Many of my colleagues, particularly in not in Commonwealth Court, I was the only candidate there, but I had some friends in the Court of Common Pleas of Montgomery County who were deathly afraid. And a lot of judges really were panicked and actually went out, formed committees, collected campaign donations, and really got out there and campaigned. I did not. I spent, I think, $200 of my own money to go to one or two events and said, so be it. My husband passed out little postcards at local stores saying, retain Judge Ledbetter. But I really did next to nothing and decided that the best thing to do was just hide under the radar. And we all won. Those who campaigned and those of us who did
But it's
virtually
now,
nothing.
a very different situation.
It is.
And so, I mean, there was just an article in the Spotlight PA, I think, and the Pittsburgh um, NPR station, WISA, sorry, I was trying to think of that,
Yeah.
that talked about how much money is being raised in the 3 Supreme Court justice
Right.
retention elections, which is an unheard of amount of money. And it's also, as you both said, it takes you away from what you do, what you as a judge, not me, what you do
Yeah.
as
Right.
on a daily basis.
Correct.
And so, it's an interesting, and I wanted to also ask, when you campaign, I know you sort of touched on it, Judge Ledbetter, but don't you have some restrictions on what you can say and can't say and how you can respond to certain, questions and ads? I don't know who would like to
Well,
take it.
after Minnesota versus White, I guess there is no complete restriction. But I think anyone who takes his or her um, responsibilities and ethical obligations seriously will not make comments that
Right.
in any way suggest that he or she would vote in a particular way or favored a particular theory. It's just it just causes well a diminution of respect
Right.
for the judiciary. It's you hit on, Deb, the importance of judicial independence, and the key is that all the courts have really is respect for what they do. We have no we have no guns. We have no legislative ability. We can't even legislate our own money. All we can do is do the kind of work that engenders respect
And
from,
yeah.
yeah,
And
I mean,
trust.
and
And
trust,
trust.
right? I mean, it has to
trust,
do with,
yes.
right? It has to do with, your performance, right? We've talked about some of the different bar associations, judicial commissions, and they have a little bit of a different process for retention elections. They do a survey of lawyers. Then if there's certain number of responses from lawyers suggesting there is a concern, and that's all it is, there is a concern with a judge, there, at least in Philadelphia, there is a investigation into that candidate, and they do a thorough investigation again. And in Philadelphia, it was just released yesterday, I believe, that some of the judges up for retention election, the Philadelphia Bar Association recommends as voting no for retention. But again, the Pennsylvania Bar Association for the appellate court justices retention elections, also it has a questionnaire, does research. They research the opinions that the judges have written, judges and justices have written, and then they make a determination whether a recommendation or not. And they've recommended the appellate court judges be retained. Sorry, it gets a little
Yeah.
confusing here. And I'm curious, like, when you're writing a decision, are you thinking about whether you're going to be retained or not, or are you writing a decision based on on the law and the statutes and the Constitution? Like, I know I'm sort of throwing a softball, but I want
Yeah,
I but I want people to understand how you make your decisions.
we have to make decisions based on the law and what's right, and you can't be thinking about any kind of political influence. We on the Judicial Independence Commission sent out a questionnaire to the common pleas and magistrate judges about what kinds of what kind of threats they had received. Some of them had received actual physical threats of intimidation, and others had received some political intimidation by local government officials trying to. And it's critical that we be able to say to. Now, I think this is much more comes into play at the local level than it does at the appellate level. But any judge has to be able to say to former colleagues, to friends, I'm sorry, I can't do anything for you because I have to be independent. And we have to act without, as they say, without fear or favor to do what's right. And that's all we can do, is to do what the law requires and what's right. Now, sometimes we don't like what the law says. We don't like a precedent that's binding on us, or we don't like a statute. but we have to follow it. And we'll write an opinion that says, we sympathize, but this is something, the law that we have to follow, and it's up to the legislature to fix this.
Right.
Or sometimes on an intermediate court like mine, we have to say, we hope the Supreme Court will fix this decision they made 20 or 30 years ago. But
But
that's
I
what
will
we
say
can do.
sometimes even your intermediate court has the final say if the Supreme Court decides not to take it up, right? For example.
Oh, absolutely. A large amount of the time, we are the end of the road because the
Right.
Supreme Court takes only a fraction of the cases that we have decided.
And I would like also everybody thinks judges just sit in a bench and make decisions, right? You sort of touched upon it. There are certain guidelines, right? Certain laws that judges have to follow when they make decisions. Can you, I guess share that and also talk about what else you do besides like sitting on a bench, because you do so much more as a judge.
Well, it's interesting.
Yeah.
I remember when I first went on the bench, talking about the independence, and we're there to apply the law without fear or favor. And your first year on the bench, this is before retention, it's a lesson that almost everybody has to learn, that I am not here for you. I am here to apply the law. So
Right.
they learn real fast that, anything that I might think, like I said, I might be ruling in something that I may not believe is the way the law should be. But if that's the law, that's what I'm going to apply on the trial court. And so I sat in family doing custody for a long time, and that was before they had all of the different factors to apply. So I did family for 7 years and absolutely loved it. And there were times when people
Bless
would
you.
come in, and I had to put my own judgment aside to apply the law. And then when I went to criminal, the same thing. Sometimes somebody would be standing in front of me and I'd have my own opinion, but if that wasn't the law, that's not the way I ruled. And or if the jury ruled a certain way,
Right.
then the jury spoke. And then in civil, the same thing, whether it's asbestos case or anything. And then as administrative judge, and as in Philadelphia, the administrative judge of the trial division oversees the criminal, the civil, and the commerce. We actually have in our common pleas court in Philadelphia a very different setup. We have 3 administrative judges because we have 3 divisions. We have orphans court, which has its own administrative judge. We have family court, which has its own administrative judge, and then the trial division, which is everything else. So applying the law and putting aside my own judgment and for all of the other judges that sit, um, it's a learned uh, lesson, but it's one that doesn't take very long to learn. And throughout your career, you are always thinking first of, this is the law, these are the facts, this is how these laws ought to be applied. And I will just say that right now, all of our leadership are female. I just had to throw that in. But anyway, all of but I say that for a reason. When all of us are on the bench, we all come on the bench with our own perspective. We all have our own backgrounds. That's why we have juries who, who are a group of your peers.
Well,
So
who are hopefully a group of your peers. So
exactly.
I'm going to put a plug in for
Well,
anyone who's listening to say, if you get a juror summons, it is really important to
yeah.
serve as a juror. Sorry.
Thank you. That's so important. One of your remaining civil rights that you want to exercise. But
I
yeah,
interrupted you. I'm sorry. But
No,
I,
that's about it. Just yeah.
but even as an administrative judge and Judge Ledbetter, you sat on the Judicial Conduct Board. Like there, you are not just sitting as a judge. Can you explain your other duties as a judge, but yet not sitting on the bench making a deciding a case? Because I think it's important. All of our judges, we want for retention elections, we want our judges to be judged by performance, but performance goes beyond what happens in the courtroom. And sometimes we don't always know what happens, I'm going to say, not in the courtroom. So like Judge Ledbetter, can you explain the other committees that you've been on?
Well, okay, I was actually not on the conduct board. I was on the
Oh, I'm
Court of
sorry.
Judicial Discipline. Which is, they're
Okay,
separate.
different.
But yeah,
Right.
yeah,
Okay.
that was quite a while early in my judicial career. And right now I'm on the Judicial Independence Commission, Pennsylvania, and we all do, well, you asked about the time we spend. I would say 10% or less of our time is spent actually in a courtroom on an appeals court. And we hear oral arguments from the lawyers, and then we write opinions, and we have a lot of reading to do. We get briefs from the parties. Sometimes we get 3 or 4 briefs from the parties. Sometimes there are extensive records we have to go through, and then we have to write opinions. And it is important to all of us in both in writing opinions and the way we deal with litigants in the courtroom. And well, let me say first, in terms of writing opinions, to write an opinion in a way that you let people know you have thoroughly considered the issues and you have considered the things that the losing party has raised, and you're not just blowing them off. And the same thing in our original jurisdiction, and I see a lot of this in our election court when we have election court, if I have to strike somebody off the ballot, I always want to let the person know that they did a good job, that we had to follow these rules about what signatures can be accepted and what can't, and they should keep trying and try again and learn from this experience and just to let people know that we respect them, because we can't expect them to respect us and what we're doing if we don't treat them respectfully, both in our courtroom time and in the way we write our opinions.
Thank you.
And to piggyback on that, for you, Judge Ledbetter, it's so important that when it's an appellate court, you're writing your decisions, and if there's a dissent, you're writing them for the person, number one, the litigant that won, the litigant that lost. You're writing it for the judges to be instructional, and you're also writing it for legislators. You're writing it so that all concerned understand why you're writing that opinion and that you hear the other side, whether you ruled in their favor or not. And it really is helpful. That's why it's so important that the opinions are well thought out, as you said, because they serve several different purposes.
Right. And we also write for the Supreme Court,
Exactly.
because some of them will in fact go up.
Exactly.
Yeah, that's true.
It's funny you say that. So PMC, Committee of 70, League of Women Voters, had a fireside chat with the 3 retention justices, and Justice Wecht coined himself like the dissent king. Exactly. Dissent king. And he said he writes for the legislators, for the litigants, for the community, so that we can, because sometimes often the laws are unclear. And so he feels, it's not that we need to send it back and get clarity. And so he's giving some guidance. Yeah.
Right. And sometimes we send it back to Judge Sheridan Harris. And in addition, we're not only bound by the law and fair treatment for all, we're also bound by the fact finding that goes on in the courts of common pleas. And if they say we believe John and not Mary, we in the appellate courts are bound by that. We can't say, well, we don't agree with that. We think Mary was a better witness. And so, you know, we write within very restrictive guidelines, I guess, to say, but that's the way it comes out right.
So I guess the other question I have for you, because there's some ads out there that are, I'm going to say somewhat misleading, but are there term limits on judges and justices and how many times they can run for retention election?
No, just an age limit.
Just an age limit, right? So, and that age limit actually was not recently, I'll say, well, recently in Pennsylvania history, how's that? Extended, right, from 70 to 75 through a constitutional amendment. So even, you know, even to institute a term limit, it would be a constitutional amendment.
Yes,
So
it would be.
yes.
It would be.
So Amy, I've already run into I've taken up more than my 30 minutes. So I didn't know if I should stop or continue, or I want to respect people's time.
Speak, Amy. Unmute.
Hey,
Colleen.
Deborah.
Oh, go ahead.
Deborah, I'm going to go ahead and bring Colleen to the spotlight. I think Amy had to take a quick phone call. She'll be right back, though.
Okay, I'm sorry.
Okay.
No problem. I'm here, and you did not take too much time. We had more time for the judges, and as a lawyer, to put the judges second in this program hurt me. So I apologize. And thank you, Your Honors. We need not go to 7:30. We've been answering questions. I've been answering questions in the chat. I see that Debbie's been answering questions. Amy's been answering questions. Michael's been dropping links. So I would just say if there are any more questions, and I don't see any open.
So I just want to say, I know it's in the link, but there's plenty of additional programming, right? There's another fireside chat with the Superior Court and Commonwealth Court judges who are up for retention election. There will be an appellate court candidate forum. I know PMC, we are reaching out and speaking. I must have at least three evenings a week I'm speaking on this. So please don't hesitate to reach out to any of us, right? This is just getting out to vote is really important.
It's so important, and I want to emphasize on that issue of judicial independence. In Pennsylvania, we elect our judges, and we're one of the few states that do so. Lots of states, and certainly the federal courts, they have lifetime tenure. Think about what the rationale for the lifetime tenure is. It's so that, at least one rationale, is so that no judge is looking at the litigants thinking, where is my next job coming from? What am I going to do when I get off the bench? You know, maybe if I rule in favor of this corporation, I can become in-house counsel. That's one rationale for keeping the judges out of the fray so that you can continue to rule without fear or favor. That's, you know, So I thank everyone. I think Amy's back. Thank you. And thank you, Debbie, and our partners. And we're going to give you a few minutes of your evening back. So thank you all. Thanks very much.
Thank you.
Thank you.
Night.
Thank you.
It's an important message, the message of judicial independence and the importance of voting in judicial elections, because some people just figure, I don't know much about this, I'm just going to skip it, and it's important.
The was it 68 or 67, the Constitutional Convention you were?
Yes,
60, yeah.
That is when the voters rejected merit selection. Voters said, we want to vote. But you can
Correct.
see what they had in mind was, and in fact, I think in some of the notes, it was called, the retention was called merit retention elections. It was
Yeah.
supposed to just be, you know, we want the experienced jurists to stay in the job, and we don't want them to go to a different job else later.
As long as they're doing their job, right?
As
As
long
long
as-
as
Right.
they're performing their job.
that
And
was the intent.
and we can do that now. I mean, there, you know, even back in 67 and 68, when they did pass that, we didn't even have as many tools, right, as we have now to investigate. So I think
Right.
it's wonderful. We have all these resources. So people should come out and vote, do their research, and make informed decisions.
Let's leave on that.
As
Perfect.
a reminder, we have put in the chat for all attendees links to the resources that we've referred to during this time together. We've put recordings to the fireside chat with the PA Supreme Court retention candidates, as well as a recording from PMC. They hosted a lunch and learn on retention candidates, so please review those resources. And also please join us for all of the events that Debbie was referring to. And we will be hosting also, I'll flag, a statewide candidate forum for Superior and Commonwealth Courts of Pennsylvania on Tuesday, September 30th from 7 to 8 p.m. So thank you again to everyone for joining us this evening. Thank you, Debbie and Pennsylvanians for Modern Courts. Thank you, Committee of 70. Thank you to all of our panelists. This has been wonderful and informative. And everybody have a wonderful night.
Thank everybody. Thank you.
Thank you.
Thank you.